If you've just been named executor or personal representative of someone's estate, you might be feeling honored and overwhelmed, because along with that title comes responsibility, legal, financial, and sometimes emotional. Hi, I'm Christine Romano, founder of Christine Romano Law. Today I want to explain what an executor or personal representative is actually responsible for, and just as importantly, what you don't have to handle alone. An executor or personal representative is the person named in a will to carry out the terms of the estate after someone passes away. If there is no will, the court appoints someone to fulfill this role. Being an executor or personal representative doesn't mean you inherit everything. It means you're responsible for managing the process. You are a fiduciary, which means you must act in the best interests of the estate and the beneficiaries. Let's break this down clearly. If probate is required, you'll need to file paperwork with the court, request formal authority to act, and obtain documentation allowing you to access estate assets. Without court approval, banks and institutions typically won't allow access to accounts. You must locate and safeguard assets, which may include bank accounts, real estate, investments, personal property, and business interests. This may involve notifying financial institutions, securing property, and gathering statements. You are required to notify heirs and beneficiaries, follow legal notice requirements, or allow time for creditor claims. Transparency is important. Keeping beneficiaries informed helps prevent misunderstandings later. Before distributing assets, you must ensure valid debts are paid, final bills are handled, and taxes are filed and, if necessary, paid. This protects you from personal liability and ensures the estate is administered properly. 5. Distributing assets. Once debts and obligations are resolved, you distribute assets according to the will, or state law if there is no will. This must be done carefully and in alignment with legal requirements. What you can delegate. Executors and personal representatives can, and often should, delegate certain responsibilities. You can hire an estate planning attorney or probate attorney, an accountant or tax professional, real estate professionals, and financial advisors. Their fees are generally paid from the estate, not your personal funds. Delegating isn't a weakness, it's a responsible administration. A few pitfalls to watch for: distributing assets too early before debts are resolved, failing to keep clear records, not communicating with beneficiaries, and mixing estate funds with personal funds. Good documentation and professional guidance prevent most issues. Are executors and personal representatives personally liable? This is a common fear. Executors can be held responsible if they act improperly, but when you follow the law, act in good faith, keep records, and seek guidance when needed, the role is manageable and legally protected. Serving as an executor or personal representative can feel like a lot, especially when grieving, but it's a structured legal process, and with the right support, it becomes far more straightforward. At Christine Romano Law, we guide executors step by step, helping you understand your responsibilities, avoid common mistakes, and delegate appropriately. If you've been named executor or personal representative and aren't sure where to begin, contact us today to schedule a consultation. You don't have to navigate the process alone, and you shouldn't.